The Justice Department is ramping up efforts to strip some Americans of their U.S. citizenship.
It's directing attorneys to prioritize denaturalization in cases involving people who commit certain crimes. Joining us now is Cassandra Burke Robertson, a law professor at Case Western Reserve University. Thank you so much for being with us this morning.
Thank you for having me. It's a pleasure to be here.
Yeah, I think, there's so many questions around this. Can you talk about how often the DOJ has historically used denaturalization and for what types of crimes we're talking about here?
Yeah. Well, once upon a time, denaturalization was actually very common. It doesn't go back to the country's founding, but it does go back about 100 years ago. The government started to denaturalize a lot of people, and sometimes for political reasons. So if you've ever heard of Emma Goldman, she was an anarchist, she was an activist, and she was denaturalized about 100 years ago. But that ended about mid-century, where the Supreme Court released a series of opinions giving more and more protections to citizenship. And then finally in 1967, the court ruled that denaturalization was just inconsistent with our democratic system. And then you saw the numbers drop. In the 50 years after that 1967 opinion, there were only about 150 cases that were filed, and most of those people were war criminals. Some of them were Nazi concentration camp guards who had escaped to the United States and kind of hidden. So the cases were very rare, and they tended to be pretty extreme.
So you mentioned that court ruling back in the 60s, but what laws give the DOJ the actual authority to denaturalize a citizen?
Well, there are two ways that somebody can be denaturalized. One way has never changed, and that is a criminal charge of naturalization fraud. Somebody is charged with naturalization fraud and they're convicted beyond a reasonable doubt, then they kind of automatically lose their citizenship as a result. The other way is the way that I've really focused on in my scholarship, which is civil denaturalization, which is just a lawsuit where the government files a civil lawsuit trying to revoke somebody's citizenship. And that is what the court ruled against in 1967. But in a footnote, the court left open a tiny loophole, saying, well, of course, if somebody naturalized unlawfully or unlawfully procured citizenship, then that citizenship can be revoked. So for decades, that was a tiny loophole that was almost never enacted except in these war criminal cases. And that's the loophole that the Trump administration is now trying to make much bigger.
Okay. So are there concerns, though, that this could be used politically or discriminatorily?
Yes, I think we're seeing those concerns already as President Trump and others in his administration have been asked about, will you look for grounds to denaturalize people that there might be a political opposition to? And the Trump administration in interviews has certainly not ruled that out. And then the DOJ memo concerns me because it does have a list of categories of criminal behavior that could lead to denaturalization, but it also has a catch-all. Any other case that the government thinks it can prove is included on the list. And in fact, the preface to that list says that the goal is maximal enforcement. So to bring as many cases as possible.
So what safeguards should be in place to prevent abuse of this process?
Right. Well, in my scholarship, I have argued that one safeguard is to get rid of civil lawsuits for denaturalization. To only have criminal denaturalization, require a criminal charge to be brought if somebody is going to be, charged with denaturalization.
Oh my gosh, I've been there. If you'd like to take a drink of water really quick, so go ahead and do that because you're talking about important stuff here.
Thank you.
Yes, of course.
So one procedural safeguard would be to not allow civil lawsuits for denaturalization at all. People aren't entitled to a lawyer. There's no statute of limitations. The evidence required is much less than what would be required in a criminal lawsuit. So I would get rid of those altogether. And then a second protection, I think, is to forbid even pursuing a denaturalization case for political reasons. That if political disagreement should never result in somebody losing their citizenship.
I think those are all important points. Cassandra Burke Robertson, thank you so much for being with us this morning.
Thank you. I appreciate it.